because obviously the other potential outcome, at least from my observation, is what we saw in the New York cases, these Bruin response laws that have been challenged. One of those cases was in a similar situation where an emergency injunction request was made to the Supreme Court. The court, took in briefings and then issued it denied that request, but with a caveat, with some notes, right? Where, effectively they said that the lower court law enjoining, blocking most of New York's Bruin response laws, the sensitive place expansions, all the stuff that they have implemented since Bruin was handed down, was a good ruling, and that the Second Circuit basically needs to move quickly on litigating that case. And if they don't, that maybe the court would then get involved. Do you see that could be an outcome here as well, or do you think it's unlikely given what you just argued there?
It's a little bit different. Keep in mind that, and this is very important, when Bruin was first decided, there was a little bit of confusion, not on the part of the people that understood the Second Amendment from the point of view of actually getting it right. But there has been an attempt, in my personal opinion, there's been an attempt by the anti-gun movement to try to confuse the situation with the Heller test. And what I mean by that is Heller is the law of the land when it comes to cases where a government actor, whether it be a state, the federal government, the municipality, it doesn't matter. If there is a ban, complete ban, or a ban on arms, such as banning semi-automatic rifles, such as banning magazines that hold more than 10 rounds, such as banning handguns, it doesn't matter. If it is a ban case, you are banned from selling, you are banned from possessing. That is governed by the 2008 Supreme Court decision of Heller that says, if that arm is in common use by Americans for lawful purposes, any and all lawful purposes, including possession, you cannot ban it, period, full stop. What's happened is and then Bruin basically was essentially saying that the methodology used in Heller is the same methodology as we look at the text of the Second Amendment as defined by the Supreme Court, and then we looked at historical analog laws to see if there's any tradition of regulation going back to the founding. But here's the difference, Stephen. When it comes to gun ban cases, the Supreme Court has already done the work and come up with a test. There's nothing else to be done except apply the test of in common use. When it deals with sensitive place questions, when it deals with licensing questions, when it deals with these other regulatory issues, those arguably still have to be resolved and figured out. You see the difference? So what's happening here is while you're dealing with the sensitive place case out of the Second Circuit Court of Appeals that I can understand why there was simply a statement by Justice Alito and Justice Thomas saying, we're going to keep our eye on you, but we're not going to get involved just yet, but we're watching. And we think the lower court decision was well crafted. It's much different in our case, or I should say our case, but in the Second Amendment's case, the cases involving Chicagoland dealing with what we're talking about today, because those are gun ban cases with very well-established tests from 2008. So I think the Supreme Court could take it to another level beyond what they did in the Second Circuit Court of Appeals cases, because the ones in the Second Circuit are dealing with sort of novel issues in a way, but the cases coming out of Illinois to the Supreme Court are not really novel. They're really just the Heller case, except you're dealing with long guns instead of handguns. But the test is going to be the same, and it's pretty obvious the outcome is going to be they're not allowed to be banned.
Interesting. Okay. I can absolutely see the distinction you're making here. And it is one that is at the core of this case, because if you read through the briefs defending these assault weapons bans in Illinois, whether it's the Naperville one or the state one, they do rely on this idea that they can employ the Bruin test for firearms technology that comes up after the founding era and presents a unique societal threat. And the argument here, the base argument is that assault weapons, AR-15s, and the like, or even really semi-automatic firearms with magazines that hold more than 10 rounds are a modern creation, and that they've led to this scourge of mass shootings, right? This is the argument, and that therefore they can reason by analogy, and they point to things like Bowie knife bans, billy club bans as examples of founding era or slightly later bans which address a societal issue in the same manner. So obviously you're a very articulate pro-gun lawyer. What is the response to that point of view?
Yeah, there's several responses. It's actually quite easy. And although I applaud the anti-gun lawyers for doing the best they can, trust me, in my career, I've had plenty of cases where I have not been on the good side, not been on the better side. I've had plenty of problems. You take your clients where you get them sometimes, and you make the best argument you can. And I think the anti-gun lawyers are doing a very good job of trying to make something out of a very bad hand. So with that said, I'm not knocking the lawyering. I think they're trying hard, but where they're trying to go is it's not going to get them where they want to get, which is to be able to ban these guns. To begin with, again, the Heller and McDonald case both make clear that when you talk about the right to keep and bear arms in America, and all rights for that matter, we do not define the scope of those rights by virtue of how some psychopath, crazy person, violent thug might misuse or abuse the rights. We define it by virtue of how law-abiding, ordinary Americans use the rights. And among other ways we do that is with what Heller articulated was this in common use test. Because in Heller, they said that the District of Columbia has banned handguns in D.C. That is not constitutional, because if an arm is in common use, even in modern America, you're not limited to muskets. That's not how it works. And because handguns are in common use by millions of Americans, which just means they're possessed. Keep in mind, Heller did not analyze how many times people use them in self-defense. Heller did not talk about how many times they were brandished in self-defense. Heller did not talk about how many times people fired guns or anything like that. They just said that millions of Americans possess handguns for lawful purposes. Therefore, it's in common use. And because handguns are in common use, they cannot be banned under the Second Amendment, period, full stop. So now you take that exact test and you apply it to semi-automatic rifles. And we know there's tens of millions of semi-automatic rifles in America. We know they're in common use. In fact, we know, not only do we just know they're in common use by virtue of all the studies done by like the National Shooting Sports Foundation, by admissions that have been made by the ATF and regulatory findings that say the AR-15 is the most popular rifle in America, not because even the Washington Post has made these admissions. We know this because of a U.S. Supreme Court case, which I always tell people you got to be aware of if you want to be a high-end Second Amendment intellectual or high-end Second Amendment lawyer. You need to be aware of the Staples versus United States case from 1984, which talks about the fact that semi-automatic rifles are commonly owned by Americans in contradistinction with, in that case, machine guns. I won't bore you with why that was important there. But the bottom line was even the Supreme Court all the way back in 1994 in the Staples case was talking about how semi-automatic rifles are in common use by Americans for lawful purposes. So that is all you really need to know. Now, you mentioned this notion of social change. There were references to maybe we need to do something different in the context of some sort of unprecedented technological change, but that is not going to work for many reasons. I won't get into all of them on this interview right here. It would take too long, but the bottom line is there is nothing in the Bruen decision that alters Heller. First of all, Bruen reaffirms and cites favorably to Heller and the Heller's test of in common use repeatedly. Bruen also cites favorably to the Caetano test. Caetano was the 2016 Supreme Court case that dealt with stun guns out of Massachusetts. And this is the key, in Caetano, they talked about only 200,000, that's 200,000 stun guns possessed by Americans. Again, there was no discussion of stun guns actually being shot, fired, used, effective, nothing. It just simply said the 200,000 stun guns possessed by Americans, they're basically in common use and they're protected. And, Justice Alito in his concurrence talks about how semi-automatic handguns are protected arms. That's important because what is the difference between a semi-automatic handgun protected by the Supreme Court and a semi-automatic rifle? There's really nothing except the length of the barrel. They're all going to be protected. But this notion of just unprecedented technological change has nothing to do with Heller. And I'll tell you in short why, Stephen. If you look at the language of Bruin, you got to be really geeky to do this, but if you look at the language of Bruin where they talk about this, if we may be able to use, or you may have to use more general analogs in the event of unprecedented social change. If you read that paragraph carefully, it talks about comparable burdens. Okay, they talk about comparable analogs and comparable burdens. There is no comparable burden in American life when you're dealing with firearms regulations going back to the founding. There is no comparable burden to a gun ban. Meaning, if you go back to the founding, you can find perhaps arguments about there's restrictions on the use of guns, when you could shoot guns, where you could store ammo, whatever it is. You could arguably find an analogs to regulations. But the one burden, Stephen, you can never find at the time of the founding or at any relevant time is the burden of being denied the ability to own a commonly owned firearm. There are no gun bans like that at the time of the founding. So even if you want to apply this unprecedented technological change language, whatever you want to call it, is all that does for you. A, it doesn't get rid of Heller, and B, it also basically talks about comparable burdens. Again, in American history, there is no comparable burden to a gun ban. There may be burdens associated with regulations and what you have to do, arguably, but there is no comparable burden. So a gun ban of a semi-automatic AR-15 or a magazine cannot be a comparable burden to anything that existed at the time of the founding. So that little caveat clause, whatever you want to call that language that the anti-gunners like to point to, it cannot work in the context of a gun ban case because it's not a comparable burden to anything that existed in 1791.